William J. Gerber, attorney at law. Thank you so much for coming on and talking with me tonight. I appreciate it.
Yeah, no problem.
All right, so tonight we're going to be discussing the details of the ongoing trial in Illinois involving hundreds of parents from dozens of school districts versus the state parties, including Governor JB Pritzker, the IDPH, and the State Board of Education, in a manner that hopefully all the listeners and myself can understand. So let's start with this. How did you and why did you get involved with this case in the first place?
So there's a group out of the western part of Illinois called We Stand for Our Students. Steve Lucy is the individual that kind of runs the organization. He got in touch with me through a mutual contact, and I initially got involved more in the teacher aspect of the litigation associated with vaccine mandates, testing mandates, and we had initially started all this litigation, filing teacher-based suits that are still pending in Sangamon County for teachers on the western side of the state, some teachers down in Peoria. Those cases are set for hearing in March now. And then we got involved in the student-related role in September of 2021 in kind of a different form. So.
Okay. And what role did you serve in the February 4th ruling by the Sangamon County judge who issued a temporary restraining order on the governor's mask mandates across Illinois public and private schools? What role did you play in that?
So procedurally, this case is a little complicated because I had a case pending up in Yorkville, Illinois, with some parents against the school district and the state parties up there. And there was 7 other cases around the state in different counties. Then Tom DeVore had filed a massive lawsuit with like 145 school districts. The state parties, Governor, IDPH, State Board of Education, filed a motion to consolidate all of these cases that were pending throughout the state of Illinois into one matter. At the time that consolidation motion happened, I had a temporary restraining order hearing set up in Yorkville for hearing. Tom had one set in Macoupin County. Those both those hearings got postponed because of the consolidation. And then in January, both of our cases got set for hearing in Springfield. So he represented his clients, I represented mine, but we consolidated into one argument. We argued both of our complaints and stuff at the same time. So the ruling was consolidated, associated with all the cases.
Okay, and what was the core argument that you and he shared then? What were you trying to get done?
So there was essentially 5 causes of action associated with the complaint. One dealt with the governor specifically in violations of what we reference as separation of powers doctrine, that he overstepped his bounds both constitutionally and statutorily in issuing the executive orders in question. Second, the Department of Public Health and the State Board of Education overstepped their bounds in issuing emergency rules in September. We requested the court void those rules, and that the executive orders that were issued by the governor and in part by the Department of Public Health, their emergency rules that were in place violated the current Department of Public Health Act and the due process procedures afforded students and teachers in matters of quarantine and exclusion from school.
Okay, so you could say that some state parties, including the governor, more or less skipped over, didn't play by the rules in initiating this mandate. Is that at all fair to say?
Yeah, it's fair to say. I hold the belief, I think initially when COVID came out, everybody probably had good intentions with all of this stuff. But now we're on Executive Order 99. that the state has issued, each one of these executive orders became more and more exertive of power and control. And as of August, you had the State Board of Education threatening school districts, threatening students, threatening parents. And at that point, Judge Grishow, in her temporary restraining order, put it very, very well that it's the duty of courts to uphold the rule of law and ensure that the branches of government fit within the bounds and confines of their authority that are grounded in the Constitution. And that's exactly what this lawsuit really tries to encapsulate, to try to make sure each branch of government, fits within the confines of their role. And that clearly was not happening as we started to get into 2021, when these more and more executive orders became rolling down the pipeline. So.
Understood. And, I know you are a lawyer, so you really have to watch what you say more than most people would. And you have to be very specific in your speech, I guess. But you said that basically the governor's actions seemed more like they were exerting power or something like that. I didn't know exactly what you said, but it seemed like he was making decisions almost like a power move or something. Is that at all what you're saying? Or like no longer is he looking out for the general public's well-being and the children's well-being and their education's well-being, but it seems like he's just making decisions for odd reasons. What do you say to that?
The Department of Public Health Act, which is the law that is in place in Illinois that deals specifically with quarantine, vaccination mandates, testing related regulations, masking requirements, has very, very specific procedures that only the Department of Public Health can do associated with testing, vaccines, masking, exclusion of kids from school, exclusion of people from work. And it spells out very, very clearly what the Department of Public Health has to do associated with those types of requirements. Mm-hmm. When the executive orders were issued, specifically Executive Order 18, that dealt with the masking of students, there were 7 or 8 different court systems throughout Illinois that had already issued restraining orders on school districts that stated these masking policies violate the Department of Public Health Act. In direct response to these court orders, Executive Order 22, Executive 24 came out that attempted to bypass the judiciary system and remove the court system from oversight in questions of quarantine that are outlined in the Department of Public Health Act, which is a huge problem. And it's a big issue associated with what we refer to as a separation of powers doctrine and the checks and balances system of the government.
Okay. And Will, I know I only have you for a few more minutes. You're a very busy man, especially during this time, but I want to ask another question. And on Tuesday, February 15th, the Joint Committee of Administrative Rules, also known as JCAR, which is a bipartisan committee composed of 6 Democrats, 6 Republicans who conduct systematic reviews of administrative rules declared by state agencies, which in this case was the Illinois Department of Public Health, they voted 9-0, essentially to block the re-implementation of the emergency rules recommended by the Illinois Department of Public Health. Does that decision made by JCAR also block Governor JB Pritzker's mask mandate for the K through 12 public and private schools in Illinois?
So during this process, after the temporary restraining order was issued by Judge Grishow, the state parties filed an appeal to the appellate court system. Okay? During this appeal process is when this JCAR decision was issued. What the Department of Public Health was attempting to do was re-implement the same emergency rules that they had implemented in September of 2021. Okay, that pretty much defined and republished portions of Executive Order 24. The executive orders specifically indicate in them that the Department of Public Health can implement emergency rules to put into effect the executive orders. Okay? The appellate court sent us a formal order asking for our opinion of whether the decision to not re-implement these emergency rules affected the appeal in any way. The appellate court was of the opinion the Joint Committee's decision not to re-implement an emergency rule, essentially stating there isn't an emergency any longer, made the state parties' argument that the governor has a basis to do all this because there is an emergency, made their whole argument moot. So there's a legitimate basis and or argument that all of these executive orders are unenforceable, and he doesn't have a reliance on an emergency argument any longer to continue to do any of the stuff he's doing. And it's raised questions and potentially requirements for motions for clarification on some of this stuff. But as of today, he's filed a motion with the Supreme Court of Illinois. So he doesn't stop.
So what's the current state of this ongoing trial? Are you just waiting for a date to have your trial? I mean, I don't know lawyer speak, but to have this case heard in the Supreme Court of Illinois, is that what the next step is?
No, we've got to get the case decided on formal merits of the case and get a formal judgment in the circuit court, but the appeals stay that process. So we can't do anything at the circuit court level when all these appeals are going on. So it just prevents us from doing anything else at the circuit court level until all the appeals are taken care of. So we haven't been able to do a whole lot more, but once the appeals are taken care of, we'll go forward on setting the formal complaints for hearing.
Okay, got it. And I'll just wrap this up with, what is the main goal here? If things go your way, how would this all end?
We want a formal ruling that the executive orders that the governor issued were invalid at the time he issued them. We want a formal ruling at the time that the IDPH and State Board of Education issued their emergency rules in September that those rules were invalid. So there's clear understanding of the parameters of which school boards have to operate, school districts have to operate, and specific parameters of which the government knows they have to operate. So if this ever comes about again, there's not questions. And so all of these causes of action need to come to final fruition so we have those questions answered.
Understood. And Will, I know you got to get going. I appreciate your time so much tonight, and thank you for explaining all that to me.
No problem.